What if the officer is wrong? What if you're misidentified? What if you're carrying legally, but the officer gets scared and draws down on you? In that split second, your only weapon isn't your gun, it's your behavior. And the courts just change the rules on how that behavior will be judged. In 2025, the United States Supreme Court made it crystal clear that everything you do before an officer pulls the trigger now matters. What you say, how you move, even where you keep your hands, it can all decide whether you walk away free or not at all. In this video, I'm breaking down the 5 factors every gun owner must know before an officer gets aggressive. These are the exact things courts now look at to decide if force was justified. And if you know them, you can turn a dangerous encounter into a survivable one. Before I break down the 5 factors, hit that subscribe button and tap the bell. You do not want to be searching for this video after an officer already has you on the ground. Let me start with why this is so important right now. For decades, courts only looked at one tiny slice of a police encounter, the exact moment the trigger was pulled. If the officer could say, "I felt endangered," that was it. They didn't have to answer for any decisions or actions that led up to that moment. Everything else, the bad decisions, the reckless moves, the failure to de-escalate, was completely ignored. All of that ended in 2025 with the Supreme Court case Barnes v. Felix. Here's what happened. A constable in Texas pulled over a man named Ashton Barnes for unpaid tolls, a minor violation. During the stop, Barnes drove away. The constable, Deputy Felix, jumped onto the hood of Barnes's car and fired shots through the windshield, ending Barnes's life. Before this case reached the Supreme Court, the Fifth Circuit said they would only analyze the moment the shots were fired. They ignored the fact that Deputy Felix put himself in harm's way by jumping onto a moving car. Thankfully, the Supreme Court, in a unanimous decision written by Justice Kagan, said no. That is not how this works. To decide if police force is reasonable, you must consider all the circumstances, including everything that leads up to the point where shots were fired or force was used. So what does this have to do with you as a gun owner? It means you must now know these 5 factors inside and out. If you find yourself in a situation where police start getting aggressive with you, knowing these factors will ensure that your behavior, your words, and your actions protect you instead of jeopardizing you. The best part? This puts you in control. If you know what courts are going to weigh, you can make sure those factors turn in your favor, not the police's. Factor number 1, the severity of the offense. The more serious the crime the officer believes you committed, the more force they can justify using against you. If an officer believes you fit the description of a violent felon, especially one they think is armed, get ready. That officer is going to draw down on you, and you should expect it when they approach. Even if you have done nothing wrong, you have to be prepared to respond appropriately. In 1995, the Supreme Court decided Tennessee v. Garner, where police shot and killed an unarmed teenager suspected of burglary, a non-violent offense. The court said deadly force is never reasonable just to stop someone from a minor offense. That has been the law for decades. But under Barnes, courts must now examine what the officer actually knew about the severity of the offense at the moment they used force. Deputy Felix pulled over Barnes for unpaid tolls, not armed robbery, not aggravated assault. Yet it escalated to deadly force. If the underlying offense is minor, it can be used against the officer in court. What does this mean for you? You cannot control what crime an officer thinks you might have committed. Misidentifications happen. Officers sometimes act on hunches rather than evidence, but you can control how you respond. If it is a basic stop and cops start questioning you about a minor offense, do not give them any reason to escalate. No sudden movements, no aggressive tones. Remember, you are carrying a gun. That puts you in a different position and a different risk level when an officer tries to escalate. If you live in a duty to disclose state, inform them right away. You do not want them finding out by surprise. Say something like, "Officer, I want you to know I am licensed in carrying. My firearm is on my right hip. My hands are going to stay right here on the steering wheel." If you are detained as a suspect for a serious crime and you have done nothing wrong, don't panic. Let the officer confiscate the gun. They are allowed to do that under protocol. Your number 1 goal is to survive the encounter. If they take it too far, under the new Barnes rules, everything they did leading up to the use of force can be used against them. Factor 2 is one of the most important in any use of force review. Did you pose an immediate threat? Under the law, if an officer reasonably believes you pose an imminent threat of death or serious harm, they can respond with deadly force. In Graham v. Connor, the Supreme Court made immediacy of threat a key factor. In Keisler v. Hughes, officers confronted a woman holding a knife and shot her within seconds. The court granted qualified immunity because the situation was tense, uncertain, and rapidly evolving. The message is clear. If cops think you're going for a weapon, they can fire and courts will back them up. Your mission is to give the officer no reason to interpret you as an immediate threat. That means no sudden movements, no furtive movements, no reaching into areas they can't see, no taking your hands off the steering wheel and reaching under the seat. And never reach for your glove box or center console without telling the officer first. They can interpret that as you reaching for a weapon. Instead, verbalize every movement. Get the officer's permission before you move. Always move slowly and deliberately. If you are in a duty to disclose state, say, "Officer, I need to reach for my license. It is in my back pocket. May I get your permission to do so?" This cuts against the officer if they later claim you were reaching for a weapon. A pro tip: keep your lap and dashboard clear. Especially at night, when an officer shines a flashlight into your car, they might mistake something for a weapon. You want the officer to see only your hands on the steering wheel and nothing else. Factor 3 is simple, but is the one I see people blow most when they get nervous. If you ever resist an officer or run away, you have given them one of the biggest legal justifications to use force against you, including deadly force. In Plumhoff v. Rickard, a driver fled a traffic stop, hit speeds of nearly 100 mph, and officers fired multiple shots, killing him and his passengers. The Supreme Court said it did not violate their constitutional rights because the flight created a grave risk to the public. Similarly, in Scott v. Harris, the court ruled in favor of police when they used a PT maneuver that caused a fleeing driver to crash and die. For you as a gun owner, this comes down to one rule: comply, don't fly. I know it sounds simple, but in the heat of the moment, people make irrational decisions. If an officer accuses you of something, even if you have done nothing wrong, the moment you take off, you're putting your life at risk. You can beat the rap, but you cannot beat the ride. Even if the stop is wrongful, your best odds are to win in court, not to flee the scene. The same goes if an officer tries to disarm you. Don't turn it into a tug of war. Active resistance gives the officer an excuse to escalate to deadly force. Factor 4 flips the script. It's all about the officer's behavior. In the 2015 Supreme Court case, Kingsley v. Hendrickson, the court said you can consider any effort made by the officer to temper or limit the amount of force. That includes giving a warning before shooting, keeping a safe distance, and clearly identifying themselves as police. Failing to do these things makes it look more like an unreasonable use of force. This is where Barnes v. Felix opens the door for officer-created jeopardy. If the officer's reckless tactics put both parties in harm's way, the use of force is more likely to be deemed unreasonable. How do you use Factor 4 to protect yourself? You prompt the officer to give clear instructions and get it on record: their body camera, your dash cam, or your phone. Say these exact words: "Officer, I am willing to comply. Please, let me know what you want me to do. Would you like me to keep it holstered, or would you like to secure the weapon?" You are putting the burden back on the officer. If they later claim you refuse to hand it over, the video tells the truth. Factor 5 is proportionality and viable alternatives. Did the force used match the actual threat? Were there safer options that the officer ignored? In Scott v. Harris, the court said officers don't have to pick the absolute least intrusive alternative, but the force still must be reasonable. If there were safe, obvious alternatives, like backup seconds away or the option to keep talking, and the officer ignored them, that can be considered in determining whether the use of force was reasonable. Let me put it all together with a simple flow chart for you. You are driving down the road. Police pull you over for a minor violation. They walk up and start asking questions. The first question you should ask yourself is, am I armed? If you're not armed, be polite but stand on your constitutional rights. Provide your license, registration, and insurance as required. Do not volunteer extra information. Invoke your rights when needed. Use all 5 factors from Barnes to protect yourself. If you're armed, especially in a duty to inform state, keep your hands on the steering wheel the entire time. Remain calm. Inform the officer you are carrying. Say, "Officer, I want to let you know I'm licensed and carrying. My firearm is on my right hip. My hands are going to stay right here on the steering wheel." Do not move your hands unless the officer tells you to. If the officer is not clear, ask, "Officer, would you like me to maintain holstering my weapon, or would you like to secure it?" Never grab for your weapon. That could get you shot. If the stop ends and you are disarmed, ask, "Officer, am I free to leave? And may I retrieve my weapon?" Reholster only after the scene is clear. Practice these steps at home. Think about what you would do. When you're on the side of the road with an officer approaching your window and you're carrying, you do not want to think. You want your hands in your mouth to know what to do automatically. And remember, none of this is legal advice for your specific situation. Laws vary by state, and court interpretations can differ. If you are ever charged with a crime, consult a local attorney who knows the judges and prosecutors in your area. If this video helped you understand your rights as a gun owner during police encounters, hit that like button right now, subscribe, and ring the bell so you never miss an update. And drop a comment below. Would you like a small card with your rights and these 5 factors printed on it? I read every comment, and I will see you in the next video.